Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Good afternoon. What a beautiful day. Not. You know what today is? Today's the first Thursday of the month. That means K. Bender Rimbaum. And we have, did you miss us last week, Michael?
Last
month.
Was it not last month I wasn't here?
Yes.
I'm back.
He was listening.
Michael.
I was listening.
So we got two, the partners in. I've never seen Rimbaum anymore.
We've seen him.
Is he still with you?
He's real.
We just left him.
Okay, so anyway, welcome guys. Good to see you, Michael
Good to
Bender
see you.
and Mr. K. That's with an E on the end of it.
Thank you.
And we got a ton of questions in today, but I'll bet you've got a lot of stuff going on.
Always.
You went to class today?
Yes.
Should it be the other way around?
No, everybody needs
Lawyers
a continuing
have to
education.
go to school, too.
Yes, continuing education. Good program today in the University of Miami.
Oh.
Condominium cluster, I think as they call it.
Cluster housing.
Cluster housing. It's great.
Well, we're
great
going to
program.
tell you all about the firm, but we like to get to our calls, so we're going to go take Maggie's call first from the 401 area code. Hi, Maggie.
Hi, I actually live in 954, but I have a 401 extension.
Okay,
I'm
that's
the
fine.
president. My question is, I'm the president of our association here, my condo, and we had a discussion yesterday at a board meeting about making it a no-smoking condominium. My question is, do we have to change the bylaws to do that, or can it be done by a board vote with the people that already smoke grandfathered in?
Maggie, how are you? Thanks for calling and thanks for listening.
I'm sorry. Okay.
You can hear me?
Yes, I can hear you.
Great.
My question?
If you're looking to make the entire building smoke-free,
The whole 5 buildings, the whole campus. Yes.
right? So not only the common element areas, but inside the buildings themselves, inside units everywhere.
Everywhere.
That would require an amendment to your declaration of condominium.
Okay.
Okay, which would require a membership vote in accordance with each of the declarations. If it's a multi-condo, if each condominium has a separate declaration, then each of the buildings would likely need to vote to approve that amendment into their declaration. In order to definitively give you guidance on that, you would want an association attorney to review the covenants and the amendment provisions and give you a written opinion as to the proper way to go about doing that and the appropriate language that would read best.
Okay. Now, how about just to make the common areas smoke-free?
The likelihood is the governing documents give the board the approval to adopt rules and regulations governing the common element areas. Assuming they do not require membership approval as well, then the board would have the authority to adopt rules that would limit areas where smoking is permitted outside of the units.
Okay. Thank you very much. I appreciate it.
You're very welcome. Thanks for calling.
You've answered my question. Okay, bye-bye.
Bye-bye.
Love that accent, too. I guess we
What
lost
accent?
our code. She had that New England accent. So tell everybody, I think he likes to do this the best, tell everybody about your firm because it's a very special firm.
Okay.
No, it is.
All right. We're very
he
special.
hates compliments, doesn't he?
Well,
He's very modest.
yes. Well, listen, I want to thank everyone who's listening. The law firm is K. Bender Rimbaum. We are a community association law practice with offices in Pompano Beach and Palm Beach Gardens, and clients that we happily aggressively represent from the Keys all the way up to Daytona as general corporate counsel. What we have here are community associations. You have your HOAs, you have your condominiums, some co-ops sprinkled in there. These are all businesses. They're not for profit businesses, but they are businesses nonetheless, and volunteer board members step up to run these businesses, and in that regard they need experts to assist them And one of those experts would be your legal expert to assist you in the ins and outs of community association law, the pitfalls, to how to avoid them. And as general corporate counsel, we assist all of our association clients in all aspects of community association representation, whether it be in reviewing governing documents, interpreting governing documents, updating governing documents, whether that's declaration, articles, bylaws, or rules. It's helping them collect their delinquent assessments through the lien foreclosure process when necessary. It's assisting them in creating contracts, negotiating contracts. If they have violations of their covenants or breaches of contract, we assist them in trying to resolve those amicably. If they're not able to, we have experienced litigators who will then assist our clients in representing the associations in court or arbitration or at municipal hearings, whether it be construction defect related complex issues, whether it's insurance related issues, whether it's a breach of contract claims, covenant enforcement claims. So it's basically the whole gamut. We offer an enormous amount of free education to all of our clients, as well as to people who are prospectively looking at the firm. And that education is in our offices. It's out and about in the Tri-County area.
In fact, there's something interesting coming up next week, isn't it?
There is something interesting coming up next week, and we pride ourselves on the experience we bring in this field, the customer service aspect that we tie into that field, and that's where not only do we give our clients the benefit of having over 100 years of community association experience from our lawyers, but you get accessibility and responsiveness from your lawyer, which I understand a lot of people don't get in South Florida.
I didn't know Robert was that old. That's amazing. 100 years?
You get 100 years.
That long.
Well, Robert's 90 of it. The rest of us are 10. You get accessibility and responsiveness. You get your opinions in language you can understand as opposed to legalese. You don't get nickeled and dimed. You get someone who's joins the team to assist the association, the management company, with helping with the legal needs of the association. And we do a good job of it, and we are proud of that.
One of the last questions that I got late last night, which you'll be getting a call, you should either today or tomorrow, a guy who's the new head of their association, he's president of the association. Apparently they don't have a law firm representing him because he said, can I do this myself? Now, I've been listening to you guys long enough to know I could say no. But I'm sure you get people who call you and say, why do I need a law firm? Why can't I do this myself? I would give the simple answer, but I'm going to let you give it.
Would you like to give it?
Sure. Generally speaking, when you're running an association, no matter the size, you're operating a business. And there are laws and there are all sorts of factors that come into play that go beyond what normal lay people are regularly dealing with, and they can be complicated and they can be exposing to certain liability claims that is best for them to avoid. So it's recommended for any association to be assisted by experts in the field, be it attorneys, accountants, management, all those things. While there are expenses that go with them, that's part of running a business. That's why there are assessments to assist in paying for those costs. It's quite often we run across associations where the boards think that they're supposed to be saving all this money that they collect from the unit owners and not spend any of it. And that's why their places tend to get run down and have problems. They need to be spending the money that they collect appropriately across all of the aspects of the operation, and that includes using experts to assist them in operating their place.
Well, if you'd like to talk, if you have a question, you can give us a call at 888-565-1470. That's 888-565-1470. Lines are open right now. They won't be open long. So if you have a question, give us a call. First of all, it's good to have you back.
Thank you. Good to be back.
It's different.
It's like all the
pressure was on. Yeah, right. Anything new going on in the industry?
Always.
In the industry?
Because someone wrote us about, I guess, about the condos and the sprinklers, and it's coming up, the date that they have to be done by?
December 31st, 2019 is the purported deadline date. Well, if you have to retrofit your high-rise condominium, and you'd have to retrofit it if you don't have catwalks and things of that nature. So if you're enclosed high-rise, meaning 75 feet or higher, basically 7 stories or higher, then there is an obligation to retrofit with sprinkler systems unless you've opted out of retrofitting with sprinkler systems. However,
That needed to be done a while ago.
right, that had to be done by December 31st, 2016. And if you did opt out, there's been a boatload of confusion because now there's something called the Emergency Life Safety System Requirements, ELSS, and a determination was made in 2017 by the state and the different fire marshals of all the counties that if you opted out of the fire sprinkler retrofit, you opted into this ELSS requirement. And as we are all learning as we go, and when I say all, I mean lawyers throughout the state, management companies throughout the state, fire marshals, is in my experience, are learning as we go as well, that these ELSS requirements include the retrofitting of fire sprinklers in some way, shape, or form in many of these buildings. So you have buildings that the legislator allowed to opt out of retrofitting fire sprinklers, which is a multi-million-dollar project in most cases. But they backed into an ELSS, or opted into an ELSS, which now has backed them into requiring sprinklers anyway. So it's a little bit of a
Gotcha.
yeah, it's a little bit of a challenge, but the deadline date, according to the statute, Florida statute 718, deadline date is for fire sprinkler retrofit is December 31st, 2019. According to the fire code, I think it's the FPCA is what they call it, that the ELSS requirement is December 31st, 2019. However, that's not what the statute stated, 718, so whether that's going to be the ultimate deadline, it is. That's why. So, and I'm so glad you brought it up.
Yeah, go ahead and explain it.
So, but the point is, the point being, let me
high-rise.
offer this: if you're listening and you're in a high-rise condominium, my suggestion is that you contact experienced counsel, and if you haven't contacted if you don't have association counsel, if you do and you're comfortable with them, call them. If you're not, call us. But you should reach out to counsel, get some guidance. At a minimum, you likely should be at least getting proposals from ELSS engineers on what they're going to charge you to do this ELSS investigation and report, and then perhaps contracting with them to get that ELSS report. But before you go that step, there's other issues that need to be discussed with counsel. So that's a very general, I'm intentionally general with this because I think it really needs to be addressed individually with each community.
Okay. Well, this is why you need to have counsel.
Well, there's an area, this is certainly an area that you need to have counsel.
Just in case they want to call you tomorrow.
Well, they can call us at 1-800-974-0680 or reach out to us at info at kbrlegal.com. Our website is kbrlegal.com, and they can go there, and there's a box to enter where you can just click on and enter your information. If you have questions about representation and you'd like legal guidance in that regard, well, you can reach out to us, and we can we'll get back with you. But it's 800-974-0680.
So we get questions now. We're starting to get more and more questions that we save up for the month. And
well, before you go to that, I do want to just say one thing before we go to the first break. Robert and I are pleased to be starting up our Ask the Attorney series. It's the 11th annual.
I love
and we're
this.
finally
Next
here. We
week.
mentioned it. We teased it all through the summer. And it's finally here next Wednesday, November 7th, in Tamarack. And it is at the Tamarack Community Center, 8601 West Commercial Boulevard. Robert and I will be presenting the first in our 11th annual Ask the Attorneys free seminar series.
It's been that long.
Yes, and it's at 6:30 p.m. on Wednesday the 7th. You do need to RSVP, and you can do that by KBR Legal Seminar at pearsongrant.com. That's PIERSON grant.com. Or call 954-776-1999, extension 242. And that's a lot of information if you're not with a pen and paper. So you can contact our office, again, at 800-974-0680, or email info@kbrlegal.com and say that you would like to attend the Ask the Attorneys in Tamarack. Give your name, association, and your email address, contact information so that we can confirm your RSVP. But that is next Tuesday. And those Ask the Attorney series are 2.5 hour programs where the attendees get to set the agenda. It's like a town hall format where we've asked people to come with their questions, come with their topics, and we spend, like I said, 2 to 2.5 hours going over anywhere from about, depending on the quality of the questions and the subject matter, we anywhere 6, 10, 12, 15 different subtopics, and digging into them, and it's great. It really allows, every time we do education, every time anybody does education, there's a topic. We'll do an hour on emotional support animals, fair housing issues. We'll do an hour on updating your governing documents. We do an hour on covenant enforcement, a 2-hour legal update. Those are specific topics. The people come knowing what the topic is and that this is what we're teaching on. And if you have questions on these subject matters, that's what we're here for. Town hall's different. Town hall, we say to you, you tell us what the topic should be. And let's get into it. Don't be so specific that we have to review your documents, because we're not going to review your documents. But come there with questions that you've wanted to ask and haven't had an opportunity to do so, or you want a second opinion. Now, again, it's for informational purposes only.
Right.
But that is Wednesday the 7th at 6:30 p.m. in Tamarack Community Center. We're excited to get started.
So Michael told you to bring questions with you.
Mm-hmm.
Doesn't matter how many questions you bring, you will have more. Because I've been to one,
and we will answer them all.
You will. You actually did. We went 2 hours one day. So
they're always over at least 2 hours.
Yeah. Now,
usually at the end of 2 hours, Robert and I will then break and go to different corners of the room and let people who are still around say, ask your last questions, because they're kicking us out.
Hey, let's go to break. When we come back, we've got plenty of questions. You've got information.
We do.
Things that are coming up in the month of November. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Hey, we are back. This is the Ask the Expert show. We're on every Thursday between 5 and 6. And the first Thursday of the month, we have the K. Bender Rembaum show. Basically, been doing this for about the last 3 years. We always have Robert K. and Michael Bender in studio. Hey, they could actually watch right now by going to your website.
That's true.
www.kbrlegal.com.
That is correct. There should be a little...
Can't look at my notes. It's not on here.
Little thing to press.
No,
to
but you
go
could
to
actually
the
watch
radio
the show now.
Yep.
Or we've got shows, past shows. You can actually go back and watch the shows. What's coming up?
What's coming up? You want to tell them what's coming up, Robert?
I didn't bring glasses.
Oh, I'll tell them what's coming up, though.
By the way, our phone number here is 888-565-1470. If you have a question, give us a call. We'll be more than happy to answer it for you. And this is the time to do it.
Oh, we mentioned the Ask the Attorneys before we went to break, and we're excited about that. That's next Wednesday. And as always, we offer free education out of both our office locations in Palm Beach Gardens and Pompano Beach. And this month, the month of November, it starts next Wednesday. And Wednesday the 7th, Wednesday the 14th, Wednesday the 28th. Those are the classes in Palm Beach Gardens. Palm Beach Gardens classes tend to be Wednesday evenings, whereas Pompano Beach are Tuesday evenings. So Wednesday the 7th, you have a Condominium Association Board Member Certification class in Palm Beach Gardens, and the following Wednesday the 14th is an HOA Board Member Certification class. And at the end of the month, on November 28th in Palm Beach Gardens, there'll be the 2-hour 2019 legal update, where CAMs can, if they haven't already, can get their required 2-hour legal update credit And it's also great for interested board members to understand legislation that took effect July 1st of this year and how it impacts your community association. So in Palm Beach Gardens, you have the 7th condominium board member cert, the 14th HOA board member cert, 28th legal update. All of them start at 6 p.m. All of them require you to RSVP to Trisha, TRISHA, at kbrlegal.com.
Aren't elections coming up the
Wait,
first
I
of the
didn't
year?
do Pompano yet.
No, aren't elections coming up?
Elections of what?
Board
There's
members?
an election tomorrow, I think. next
elections
Tuesday.
of board members depend on
different
your
times?
governing documents,
Okay.
and they're all throughout the year. The largest part usually go November, December to March. Some of
Okay.
that string, because when you have the
During
quote unquote
the
snowbirds,
season.
people are
That's
in
right.
town. But we have communities who do elections, every
So
month.
if you're thinking about running for the board, these classes are very important.
Well, the certification classes, if you are thinking about running within the next 12 months, you can go and take your board member certification class now, and your certificate will be valid for 1 year. So if you do get elected to the board or appointed to the board within that 1 year from when you've taken the class, you are considered to have been certified in accordance with state law, and you can provide the certificate to the association secretary or the management company to have on file, and you need not have you'd be considered certified so long as you stay on the board uninterrupted. You should continue to go for education. As long as you're staying on the board, you should always go to different education classes, even maybe take the board class, cert class a second time, because it can't hurt. It's just going to benefit your community. And the other classes in Pompano Beach, as I mentioned, are Tuesdays. And we have 2 classes this month, Tuesday the 13th and Tuesday the 27th, starting at 6:30 p.m. The first class is the condominium board member cert class. And then and that's on the 13th. And then on the 27th, we have a fair housing class, emotional support animals, actually what it's fair housing classes, assistance animal versus pet is actually what it's called, and it's basically an hour dedicated to explaining to board members and managers the
Ins and outs.
ins and outs, I guess, of how you handle fair housing claims, in particular the claim for an assistance or an emotional support animal. And with recent 2017 rules and regulations from HUD, there is more information to share. And it's an excellent class because it's still out there. There's still questions. I still recommend that when you get those types of when someone says, if you have a no pet policy or a pet restriction like no pet, either no pets allowed or maybe pets only, smaller pets, or however it works, and someone wants an animal who looks just like a pet, but they say it's in a support animal of some kind, you never say no, but you also shouldn't automatically say yes. You should do your due diligence, because either way, one could expose you to a fair housing claim, the other could expose you to a breach of fiduciary duty. So there's very simple ways to protect yourselves and the association from these liabilities, and that is why you want legal counsel.
Okay. Phone number here is 888-565-1470. We have lines open. I have a question from somebody. Apparently they talked a friend into running for the board. This person.
Did they give their name?
Actually, they did. Jonathan.
Jonathan has this question. Okay, Jonathan, if you're listening, here's your question.
And then this person who he got to run for the board is now suing the board.
Is he on the board as well?
Not yet. Can he still run?
Well, there's nothing in the law that precludes him from running and serving on the board when there's legal action between him and the board, so long as there isn't what the statute provides for to disqualify, being delinquent in assessments for more than 90 days of $1,000 or more, or convicted felon, or suspended by the division. Convicted felon without civil rights restored for 5 years prior to that. So, other than that,
Doesn't disqualify
it's a
him.
political issue that can be used internally if the board wants to point out to the rest of the owners, hey, you want a board member who's suing your association, then vote for this guy.
Okay. Let's go to the phone. We have Savannah.
Savannah.
Hi, Savannah.
Yes. Hi. I am a owner of we're in a condo. We've got about 260 units, and we don't have a website yet, so we don't have a repository for our minutes. And the board, every other month, they do one in the day, and then the next month they're in the evening. Well, I work, so I can catch it every other month. So they did one in the daytime 2 months ago. And I have been emailing and calling and requesting to see the minutes. And I have had no satisfaction in this. Do they have to show me the minutes?
Oh, go ahead.
Well, Savannah, first off, you are aware that they are required to have a website in the near future, and hopefully they're working toward
big
doing
condo,
so.
she said.
And there are over 200
Okay.
units. And
Well, that would have been discussed if I could see the minutes.
but with respect to you getting the minutes, you don't have a right to demand that they send you the minutes. That's not something they're obligated to do. What you do have a right to is make a written request to inspect the records to see the minutes in that fashion. So that may take some of your time to work out with them a mutually convenient appointment for you to come into the office, wherever they keep the records, and review the minutes in that setting. If they want to be nice, they can send it to you, but they are not obligated to reply to your written request of that nature.
Okay.
So
Okay, well, thank you.
So I do suggest you send a letter requesting access to the records. Now, depending on your particular condominium, they may require you to submit it not by email, but by either letter, U.S. mail, or possibly even certified mail. The safest approach is to send it by certified mail, and that way the time frames under the statute will kick in as soon as they receive it. Then they have to provide you access within 10 business days.
Okay, thank you. Do I have time to ask one more question?
Sure.
Why not?
Okay. So I'm a fairly new owner, and we got the packet to look at the budget for the next meeting that will deal with the budget. And there's a question of reserves, and currently we don't have reserves. Could you tell me just globally, because you have so many clients, is it more common for people to have reserves now or not have reserves?
I mean, that's an interesting question. I don't know that
We're not
we can-
actually privy to all of their budgeting aspects, being their attorneys. We can tell them what they're required to do.
Yeah, I can tell you that I have found what I have seen in it with a very small sampling of our client base is a few of these communities that have for years waived reserves are considering at least doing some partial funding of reserves. I have seen a small trend in that direction. Again, a very small sampling. But it is definitely that is the epitome of a business decision for the board, because in a condominium setting, the law requires that the board create a proposed budget with fully funded reserves
Every year.
every year, and that's what's supposed to be presented as a proposed budget. If the board does not want to, if the board thinks it's in the best interest of the association to have fully funded reserves, notwithstanding it might increase maintenance assessments for the all owners,
Right.
including board members who are owners, they do not have to put a question of, hey, we're going to partially or waive reserves. But if they do want to offer that question to the members, if they do want to do anything other than fully funding, then they have to go out to the membership and ask the membership by a majority of the quorum, meaning a majority of the people who vote by in person, by proxy, if they can do less than fully funding of reserves. That's in a condominium setting. In an HOA setting, reserves are only going to be relevant if the developer had reserves in its original budget or any future budget before turnover, or if the membership at any time voted for reserves, which to date I have not seen.
Okay, they presented a budget that shows it both ways, and you have a choice of saying whether you want it one way or the other way. So
Right.
apparently they're doing what they should.
Yes,
Okay.
they are.
Well, I'll be going to this meeting because Lord knows when I'll see the minutes. But thank you.
You're welcome.
Oh, good luck.
Thanks
and
for
thanks
calling.
for listening.
Okay. All right. Bye-bye.
Bye-bye.
Let's go to break. When we come back, we have more with Ask the Experts, the K. Bender Rimbaum Show. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
And we are back. This is the Ask the Expert show. If you'd like to give us a call, if you have a question, especially if you're a board member or a management company, phone number here is 888-565-1470. The first Thursday of the month, we have the K. Bender Rembaum show, and they will answer any question you have. And
well, as long as it applies to community associations.
They don't do bankruptcy at all.
We might try at anything, but let's stick to community associations.
Okay, yeah, there's enough there. It seems like we just opened up in Houston, Ask the Experts. They got a lot of HOA firms there, community associate in Houston.
Firms, huh?
Yeah, I was surprised. A lot, like 9 pages. So,
hope they're listening.
I don't think so. I don't think so. So anyway, if you have a question, call us at 888-565-1470. Well, Roseanne, I guess she has a lot of time on her hands now.
I think you see people stop calling because they can just email or text you questions now.
Yeah, but it's better to call.
We want you to call in, people.
Give you your 15 minutes of fame. So Roseanne's from Pompano, your home office. Are directors on notice with the state to make sure their documents don't expire?
No. Next question.
That question was written in a kind of a way that's hard to understand for most people, but what she's referring to is for homeowner associations in particular, the Marketable Record Title Act is a provision in Florida statute that provides that if documents are not renewed in the public records in a certain procedure within 30 years of a certain date, which is often difficult to get precise on, but if you go by the date of the recording of the declaration itself, that's a good rule of thumb, then those documents could expire, and then another procedure is required which takes a vote of the owners to get them reinstated. And that can create a big mess in the community. The board will not be able to collect assessments. It won't be able to take enforcement action when people are violating. So it's a good idea to do that. Now, there is some talk, I understand, of the possibility, in fact, it was newly adopted, requiring the boards in their first meeting of the year to put that on their agenda.
Yeah, there was some legislation that took effect October 1st of this year, so just last month.
Last month, yes.
Modifying Chapter 712 of the Florida statutes, which is your Marketable Record Title Act. And among those changes, there is some indication that the first meeting after the organizational meeting every year, the board is to consider whether they need to address preserving their covenants. So
that's the state's way of making sure that they're aware of it.
So the answer to the question that was raised is no. There's no state database that's going to contact you and say, hey, your documents are expiring. You should have association counsel should be contacting you. I can tell you, like 3 years in advance is when we've been sending out first notice. If you haven't already, if they don't reach out to us first, it's, hey, 3 years from now, which is plenty of time. 2 years from now, if you haven't reached back. 1 year, 6 months, hey, you're running out of time. So really, I'd say the board and their management team should look at the date the declaration was originally recorded, and go back 30 years from now. So that would be 1988. So if you are looking, if your documents are recorded anytime early in 1988, you're probably in trouble. But if they're recorded in 89 or 90, then you want to contact this experienced counsel and say, hey, what do we need to do to make sure these things are preserved? The piece of legislation that was approved October 1st does offer another potential option for preserving documents other than a procedural board meeting affidavit package that we assist clients with, which is if you amend your documents, then the amendment, when recorded properly, will extend another 30 years. So if you're looking at updating your documents, HOAs know this. In Tallahassee this session, like last year, there's going to be a big push from a certain section of the business public, short-term rental people, who will be wanting to restrict HOAs from putting in lease restrictions. And so if you are looking to do lease restrictions, like limiting the number of times people can lease, how long they can lease for, those lease restrictions you should amend and put in place before July 1st of 2019. So those are the kind of things you want to be looking at and getting with your, again, you asked earlier, and I keep coming back to it. These are really solid reasons why these corporations need experienced general counsel. These are big time issues that can have a significant impact. So let's take another call.
Let's take another call. Anna.
Hello.
Hi, Anna.
Hi, how are you?
Good.
How you doing, Anna?
Pretty good, thank you. I have a question on, as a condo owner, if you've had problems within your home, like damage because of the roof leaking, and you've had to repair it several times, you asked for the association to help in getting that roof fixed, you've paid monies in for having the building painted, but never anything is done, and now the ceiling within the bathroom is damaged again. It's a health issue. We've gone to the association, we've asked, we've sent certified mail. Nothing ever happens. Is there somewhere that we can go for help?
Well, as a unit owner, addressing an association that's not responding to its obligations to maintain the common elements, you're left with needing to bring an action for arbitration with the division of condominiums if the board is failing to do what it's supposed to under the governing documents, or it may require a lawsuit in the courts based upon the breach of the fiduciary duty of the board to properly maintain the common elements. Most likely it would be that the division jurisdiction may not be sufficient, and while you don't necessarily need an attorney to help you with the division, you definitely will if you're going to be bringing an action in the court system. From what you've described, it sounds like the board should have addressed the issue of the roof leak when it was first brought to their attention. If they did not, any subsequent damage that you experienced within your unit would be damages that the association would be obligated to reimburse you for based upon their negligence in failing to take care of the problem. So you may have to seek an independent attorney to assist you in dealing with the association.
Okay. The president of the association has been in there for probably the last 7 or 8 years, and he owns a lot of the units there because people have just left. And I don't know what else to do.
Well, I think that getting the assistance of an independent attorney is
familiar in this area.
Right, familiar in this area is your best bet in pursuing that.
Okay. I appreciate your help and your advice. Thank you very much for your time.
Thanks, Anna. Call
Thanks
again.
for listening.
Good luck.
So we have another caller.
Thank you.
We have Sharon. Thanks for holding. Hi, Sharon.
Hi there. I just had a couple questions. So we live in an HOA, And we're having a little bit of some issues with some of the residents that we have there, so they're not keeping up their property and things like that. And we've sent them letters and, done all of that, and it's still not working. So I guess my question is, what is the next step that we need to be doing? I'm new to the board, and the people who have been on the board members that are on the board, some of the board members have been there a very long time, and they're not very quick to do things. So I'm trying to speed up the process, but my question is, how can I speed up the process with a board that just won't move on things like people not keeping up their homes and keeping, cleaning their roofs and their lawn service and things like that?
Well, Sharon, when you say that the board is slow to move, is it are they reluctant to pursue legally?
I would say yes. Their reaction is, okay, well, we'll send them a letter. Okay, so we send the letter, and then we send another letter, and whatever, but nothing moves. And
if nothing, if they're not responding to the letters and the violations continue to exist, there's one thing is, if you have the ability to have independent owners sit on a fining committee, then fines can be established, and that might persuade people or to dissuade people from the violations, clean up and stop committing these violations because they don't want to be fined. The other is, if they're not complying, they're not responding to letters, then really the board does have to make the business decision to move forward and meet their fiduciary duty to uniformly enforce the covenants. They're sitting there running this business. This business has covenants, which is a contract between the association and all of the owners. And the contract says that you're going to maintain your property. And if you fail to maintain your property, then you're in violation, you're in breach of this contract, and there are penalties that are potentially available. But the directors who have volunteered have said, hey, we're going to govern this association, this corporation, and so we're the party on the other side of this contract. And if we don't enforce this term, then other owners in this community can say, hey, board, you're not doing your job. You're breaching your duty to us to maintain this the community. And that is one potential. The other, of course, as you're already pointing out, is you're going to have homes that are run down. They're not being properly maintained. The potential for that causing, especially if you're in a community where they're attached, where one person not maintaining is going to lead to issues in other attached attached units. And if you don't address violations in a specific amount of time, and we always recommend within 1 year of when you know or should know of the violation, anytime, the longer you get beyond a year where a violation's been allowed to exist, you run the risk of having a waiver defense, depending on the violation. So if someone, for instance, has made an unauthorized alteration, or has unauthorized occupants, or in a community of no pets has a pet, that they're saying is a pet, and you don't address these violations within a year's time, anytime beyond a year, they have an argument when you try to bring legal action that you knew about it and you waived your ability to enforce it. And waiver can be a successful defense if they can prove their defense. The problem with waiver is you waive against that individual, but now you have not only do you waive against that individual, but you're waiving against anyone else in a substantially similar position. Because if a new owner comes in and commits the same violation, and you go right after them, you don't have a waiver issue because you're timely, but now you have an issue of selective enforcement because you let party A commit the violation. You can't go after party B for the same violation without facing a risk of selective enforcement defense, another successful defense strategy. So the rest of the board needs to be told that they have a fiduciary duty to enforce the governing documents uniformly, and a failure to do so could lead to the inability to enforce these documents without other remedies taking place, grandfathering in, and it gets to be a bit messy.
And on top of all that, since the board is in breach of its fiduciary duty, there's also the exposure that any unit owner can bring an action against the association for that failure and how they're damaged as a result of it. So it is actually a multiple-pronged exposure to the association in failing to act. The best
with a simple remedy,
right,
which is ACT.
The first step is have the association attorney send a demand letter to the owner, which they typically take more seriously than the ones they get from the board itself, and then consider pursuing it through the court system as necessary. The first step requires the association and the owner to go through a mediation process before a lawsuit can be filed. So there is a possibility of resolving the case relatively quickly and relatively inexpensively, although oftentimes in the mediation setting, the association is not going to get recovery of its full attorney's fees, if any, in the settlement, but at least the issue of the violation has been resolved. So those are some of the things that the board should be considering and taking action upon.
Okay, that's great. That's very helpful, and it's just I'm trying to get my arms around all of it too, to get them to move forward. So another issue that came up, and this is less a legal question than it is maybe a management question, but so there's been a lot of discussion on our board about whether we should have a manager on site in our community or we should hire a management company. So that is a board decision, correct?
Yes,
yes, it is.
Which way we want to go?
Of course,
okay.
but also, Sharon, those are not mutually exclusive either. You have an on-site manager who could be an independent on-site manager, but there also are many qualified management companies who, if you are looking for an on-site manager, they will give you the on-site manager, but then also give you the quote-unquote back office support or corporate office support for that manager with regard to issues like your accounting issues and things of that nature. So it really just depends on what the board is looking for, what your price your price point is. And my recommendation in that regard would be to interview management companies, talking with them about the benefits of them putting someone on site. And then there are many managers who just are independently do on-site work, and talking to some of them and then getting a feel for what you think would work best.
Okay, got it. Okay, perfect. Thank you so much. You've been very helpful.
Right. Where the legal comes in there, by the way, is before you sign any contracts, you should always have your lawyer review those contracts.
Yeah, of course. But yeah,
thanks very much.
That would be that's what we need to do.
Right.
Just a matter of getting them to do it. Yeah. Okay.
Right, Sharon, thank you.
Thank you.
Just in case they need to call an attorney tomorrow, what is the number at your office?
They can reach us at K. Bender Rembaum, 800-974-0680 or info@kbrlegal.com. And when we come back, I do want to bring up one more time that town hall. And I did fail to mention we have two great sponsors for that program, and I want to make sure they get their proper shout out.
Yeah,
so
absolutely.
Let's come back
Let's
and do
go
that.
to a quick break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Hey, we are back with our last about 10 minutes, and we're here. This is the Ask the Expert show. We're with K. Bender Rembaum, their association attorneys, and they've been with us for a long time. You had some information you wanted to get out there, and some sponsors.
Yes, if you were listening earlier, or if you're now listening, we are excited to be starting our 11th annual Ask the Attorneys series, which is a town hall forum-like series. They're starting in Tamarack next Wednesday the 7th at the Tamarack Community Center. on 8601 West Commercial Boulevard. It's an evening program, starts at 6:30. There will be good food and drinks, non-alcoholic. And I want to thanks in large part to our two wonderful sponsors, Florida Community Bank and Community Cable Consultants, our proud sponsors, and they will both be present, and they'll be able to address not only the questions, not only will we be able to take topics on legal issues, we're going to have we'll have experts there on banking for your community association, and our community cable consultant, Marcy Gershoni, will be present, and she's been at earlier Ask the Attorneys, and she's able to speak with answer questions that board members may have with regard to bulk internet or bulk cable or bulk community service type programs. So Florida Community Bank, Kathleen Karpovich, I believe, will be present. She's great, knows all about association banking, whether it be for day-to-day banking or whether it be for borrowing of loans for construction-related projects. And Marcy Gershoni from Community Cable Consultants, both will be there. You can thank them both in person for the wonderful food and drink that will be provided. And between them and Robert and I, will have 2.5 hours of just answering a bunch of questions on all different topics. And it's a great evening. It's all free. All free to attend, yes.
But if you're way up north on the same night, and you can't come down to Tamarack, you could get a
board member certification class in Palm Beach Gardens. And for all those of you who cannot make Tamarack, you can go to our website at kbrlegal.com. We will be hovering 2 programs in January, 2 in February, and we have 1 in April. We are still looking to schedule for March. But we do have 5 other programs already scheduled around the Tri-County area.
Interesting you brought up about the cable. We got a note from Shirley, who is a property manager in Oakland Park. She said, my company manages several properties. Can bulk cable contracts entered by the developer be canceled by the association after the turnover?
If they're a condominium.
Are they?
It just says that she's a property manager.
Maybe is the answer to that question. There is language in Chapter 718 of the Florida statutes. There's also language in 720, I believe, with regard to contracts post turnover. That's going to be something that would be needed to be, the specifics of which I would encourage anyone who's in that situation, including the author of that question, to reach out. We're happy. This is an area we work with all the time, dealing with terminating contracts post turnover, but they are contracts that need to be terminated pretty quickly after turnover. If you wait more than 18 months, you're likely out of luck. And it's possible if you have meetings in between there and don't address them, you could be out of luck. So there are statutory procedures in place, and we encourage that you contact Association Counsel, or we're happy to assist you. And what I do want to let listeners know is we do represent the majority. We have over 1,000 communities, and for the most part, we are general corporate counsel, which means we assist them in all aspects. However, we do get just the other day, last week I had 2 different associations who had very specific issues that they wanted to ask us to assist with, and whether it's a trial run for us, to take over the rest of the business or not, I don't know, but I don't care.
It's a good start.
Well, listen, regardless, if it's a specific issue and that's what they need our help with, then we're happy to step in and assist them with a specific matter. And then when you retain our firm, there is no annual fee. You can hire us. We help you with the issues you'd like. And then if you don't need anything from us for a few months, we are on the sideline for when the next issue comes up. So whether it's a single issue like trying to address turnover cancellation of contracts, or whether it says you're ready to have us assist you in all aspects, contact us at 800-974-0680 or kbrlegal.com. We do free consultations with individual boards or groups of boards. That's something you can ask us about as well.
Here's Gail in Fort Lauderdale. She says, I live in a 55 and over community co-op. Do the rules apply for our reliable survey that show 80% of the units are occupied? Are we required to do a reliable survey?
These are good questions.
It's a very good question, and the answer is yes.
No.
Yes.
In order to maintain the status, well, when you call yourself an over 55, what that basically means that you are able to legally discriminate against families with children, which is a protected class under both state and federal constitution. This is an exception if you qualify. And part of the qualification is 80% of the units must have at least one permanent resident over the age of 55 years, and that there be every 2 years updated surveys kept in the association records that identify the individual in occupancy who is over 55 years old. So that would be the quote-unquote reliable survey. There's also a filing with the state of Florida that is considered a good idea. While there's no penalty if you don't, it could create problems if you fail to do that as well.
We have Barbara in Boca. What is the power of the president? We are not happy because the president has our attorney at every meeting because of infighting. We are not happy about having the attorney at every meeting.
Why? They're such nice people.
Well, Barbara, I'm going to have to side with the president on this one. Well, the answer, what is the powers of the president are primarily set forth in the Articles of Incorporation and or the bylaws of the association. Those are the two documents that create the actual corporate entity and then spell out how the corporation runs. So that's where you would look for powers. The president primarily is responsible for day-to-day operations, and if there are issues at board meetings, and which is precluding the board from being able to conduct business, then it is necessary that business be conducted. If having the attorney there assists with running the business, then the board should be in favor of that. The president's powers can be expanded or diminished by a vote of the rest of the office, of the rest of the board, the directors, if that is appropriate. But again, it would need to be, it's something that should be discussed with council and then addressed at an open meeting as an agenda item.
Do you have certain clients that you are at every one of their meetings?
They're not every.
Okay.
No.
We've had in the past.
We have,
depends on the
So
community.
maybe they think there's some kind of maybe conflict. But anyway.
Well, no, what it is, they don't want to pay the expense of
Yeah,
having them.
that's what
And
it's-
really, the attorney shouldn't need to be at every meeting either.
Okay.
But anyway, we want to, kbrlegal.com is the website.
Check out our upcoming events of education.
Right, 800-974-0680, info@kbrlegal.com. Yes, get to the website, look up everything we talked about today, and watch the show again. And,
Come see us next
thank you,
Wednesday
everybody.
in Tamarack.
And keep sending those questions. Great questions.
Yes.
Hey, we'll see you again with more Ask the Experts next week, and the guys will be back the first Thursday of the month.
Happy
That's right.
Thanksgiving.
Oh,
Yes,
that's right.
happy Thanksgiving.
Take care.
Thanks for listening to the Ask the Experts show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.